All right, breaking news right now out of the Supreme Court. We are just learning that they have made a decision on the voting rights issue that has been before them. It's a huge decision. Shannon Bream joins us now live outside the U.S. Supreme Court with more. They have made some changes to the way that the Voting Rights Act is viewed. Shannon, what can you tell us?
Well, Martha, for folks just to remember what this is about, the Voting Rights Act was passed back in the mid-1960s, and it's all about remedying discrimination against minority voters. It was passed so that certain covered jurisdictions, there are several states, a number of other chunks of states, where there's been a history of discrimination in the past, and because of that, if they want to change voting procedures, they have to go to a federal court or the Justice Department and ask permission first. A number of these states have argued it's time-intensive, it's very expensive for them to do it, and that things have changed over the years. Section 4 of the Voting Rights Act is the one that figures out or calculates which is going to be a covered jurisdiction. In an opinion by the Chief Justice, they have just called Section 4 unconstitutional, saying nearly 50 years later things have changed dramatically, and largely because of the Voting Rights Act. Voter turnout and registration rates in covered jurisdictions, those places where they're essentially under a penalty and have to get national approval from the Justice Department or a court, federal court, to change things, they say things are now approaching parity. So Section 4 now found unconstitutional, meaning it could change everything about how it's decided that you're a covered jurisdiction and whether you no longer have to be a covered jurisdiction. You can get out of it. But essentially, our first read on this opinion is it's a major change to the Voting Rights Act, striking down Section 4 as unconstitutional. Martha?
It's very interesting. You know, talk to me a little bit about what kinds of measures these states have tried to get through in order to change the voting rules in their communities, and what this might allow them to do now.
Well, as I was explaining a little bit about that, if you want to make changes and you're one of these covered jurisdictions, you do have to spend a lot of time and money petitioning the federal government, which can say no. It often says yes and says, yes, you have remedied things, we will approve a specific change or let you opt out. But it costs a lot of time and money, and so there are places that want to change a polling place. They want to change the hours that you vote. They want to change a location. They can't do any of that without spending the time and money to get the federal government's permission. And a number of these states say, hey, you know, there's been a huge shift in our demographics, our population since 1965. In the interim 50 years, essentially, a lot of these attitudes and discriminatory measures have been remedied to some extent. Everybody who argued this case on both sides admitted we're not a perfect country. There are still issues of race and discrimination. But the fact is, many of these places have made great strides, and they think, we don't need to be under these provisions anymore. Yeah. Come check us out. There haven't been complaints. We've remedied these things, and we shouldn't still be under this federal law, essentially, that costs us a lot of time and money to make changes that other parts of the country would never have to think twice about.
Understood. Now, what about the question of voter ID and requiring that? Does that come into play here?
That it could tangentially be come into play, because essentially what this Section 4 that the Chief Justice in writing for the majority has called unconstitutional, it decided who would be under these covered jurisdictions. So yes, if you're going to have voter ID, if you're going to change your districts, that's something you'd have to come ask the federal government about. But if the Section 4 formula deciding that you're covered, that you meet the criteria for being covered, if that's thrown out, maybe you're not covered anymore, and so maybe you can make those changes, whether it's voter ID or something else. Those things are going to take some time, I'm sure, to trickle through as we read the rest of this opinion. But what it looks like now is a lot of the jurisdictions that are covered now, the formula for deciding who's going to be covered, apparently at this point in its current form, is unconstitutional.
Just one more quick broader question for you, Shannon. You know, yesterday we had the affirmative action decision basically kicked back to the lower court. These are all part of a larger umbrella in terms of equal treatment under the law and the changes that came about in the late 60s.
It's true, and a lot of what we're going to be seeing decided here at the court has roots in those things. The conversation about civil rights and who is equal under the law with the same-sex marriage cases that we anticipate we're going to get either tomorrow or Thursday. We're still waiting on guidance from the court about what will be the next day they're going to meet. But all of those things have a common thread in talking about a couple of things. First of all, civil rights issues, equality under the law, and also states' rights. That's a big, big theme through a lot of the cases we've seen here this year at the court.
Fascinating. Shannon, thank you very much. We'll talk to you later.
Oh, well done, Shannon. Catch your breath, too. Judge Napolitano now, Fox News judicial analyst. And, sir, good morning to you. 1966, the formula was rational in both practice and theory. Coverage today is based on decades-old data and eradicated practices. How does this change now? What does this mean, Judge?
Here's what it means. The law in 1966, Bill, basically said if you are in certain counties in certain southern states, then all laws that affect who can vote and how they can vote are presumed unconstitutional unless approved by bureaucrats in the Justice Department. The court upheld that for many years. Today, the court reversed that and said people who make decisions as to who can vote and how they can vote in these southern counties, in these southern states, may make their rules and someone can challenge it. It's not presumed wrong just because they're in the South and they made the rule. It's a valid rule and it will be followed unless dislodged by the court. So basically it makes it more difficult for people who don't like, oh, we're going to change the place where you vote. We're going to make you come up with a voter ID. We're going to change the time for voting. Things that happen all the time in the North without involvement of the Justice Department now can happen in the South.
Judge, let me ask you two questions. It required the states with a history of discrimination against minorities to take extra measures to protect their voting power. To whom does this apply? It's Alabama? Is it Mississippi? How many states?
Oh, it applies to 12 states, but not to all counties in those states. But not after today, Bill. Basically, the Supreme Court said that history of discrimination against African Americans is history. It's eradicated. There's no longer any contemporary data that it's still going on, and therefore there's no reason to impose this additional burden on those states while not imposing it on any others.
All right, Judge, thank you. We're going to get a commercial here from the dissent. I'm just reading this right now. The sad irony of today's decision lies in its utter failure to grasp why the Voting Rights Act has proven effective. That from the dissenting judges. Thank you, sir.
You're welcome.
If there is more, we'll bring you back, okay?
You got it.
From the Supreme Court.